Good morning. High 10 George Realty, Coldwell Banker Commercial George Realty. It's my pleasure to be with you to conclude the RPA training. This is session 3. I will hit the high points in the paragraphs, and I've added some forms that have some information that you will take a look at with me. And then next week we'll be starting on the new forms that were released. So we'll go over, just so you have some exposure to them, I'll go over the new forms beginning next week. Okay, so I'm going to share my screen and we're going to get started.
Good morning, Michelle. Good morning, Peter.
Hey, good morning, Oscar, and everybody on Zoom and
Good
in the
morning, Oscar.
Morning.
Okay, so we left off on, let me see, this is page 11, buyer right to cancel. These are important paragraphs because before any cancellation occurs, either party needs to notify with a notice to perform. You can't just go in, escrow, and cancel. That means even if there's no deposit funds, you still need to go through the appropriate steps, notice to perform. So the buyer does have a right to cancel based on a contingency, a good faith cancellation based on contingencies. I have a cancellation document in this training session that I'll go through with you. So you have to first deliver the seller a notice to perform it, and they get 2 days per contract. So if it's delivered improperly, meaning that you didn't give them the correct amount of time, it's deemed void and you would have to do it again. Okay, so the buyer has a right to cancel and provide first providing a notice to perform. If the seller doesn't perform, they can deliver the cancellation of contract and release of forms, deposits. That's on a CAR form that we'll be going over. So each side has a right to cancel for specific performance. The seller can send the buyer a notice to perform, and the buyer can send the seller a notice to perform. But it's really important that you don't jump the gun. Your escrow officer should be reminding you that you need to do the appropriate cancellation. Okay? So, effective removal of contingencies. If the buyer removes any contingencies or cancellation rights, the buyer has conclusively deemed to have completed their investigation on that contingency. They've reviewed all the reports and other applicable information and disclosures containing to that contingency, and they've elected to proceed with the transaction. They are assuming all of the liability, responsibility, and expense for the non-delivery of any reports, disclosures, or information, very important, outside the seller's control. And for any repairs, corrections pertaining to that contingency or cancellation right. So what would be something that would be outside of the seller's control? It may be something that they could have went to the city and checked. So make sure that when you are directing your buyers, you don't check for them, but they're welcome to go check with any government entity they feel necessary, including the city. So if they want to go look for permits or things of that nature, direct them to the city. If you need to drive them, that's fine, but don't do the speaking at the counter for them. Let them be the one in charge of the questions they're asking, and you can just stand in the background, okay?
In one of the open houses I was going to, they were selling a property that was as is. Big, nice, but it was broken down, needed a lot of work. So a lot of the people that were going there, they were asking certain questions, and they said it's as is. You would have to go to the city and ask for certain things if you want to ask, about building and knocking it down and doing certain stuff.
Correct.
They said just go to the city and see what permits you're allowed to.
Right. And even if you think you know the zoning, I wouldn't be quoting it, because sometimes things get downgraded or upgraded. And it's best they check with the city, especially when they want to knock down, add, build, anything like that. They need to check with the city to make sure. Perhaps there's a tree sitting at smack dab in the middle of the backyard that is a protected tree. So all of those things they should check with the city, okay? Those things do happen, by the way. There could be a big oak that can't be, knocked over, okay? So if the seller removes any contingencies, they've satisfied themselves the same way as to the matters of that contingency. So what if you're rolling along and the escrow doesn't look like it's going to close on time and the seller's insisting it close on time? You need to provide, if you're representing the buyer, a demand to close escrow, or the other way, the seller can provide a demand to close escrow. You have to give them 3 days to get ready to close and close it. And you cannot, if you deliver that wrong, again, that would be void and you're going to have to redeliver it. So there is a demand to close escrow. I've teed it up in this training. I'll show it to you. So if the buyer's agent is saying, oh, we need, 2 more weeks, and the seller's not in an agreement and you already have agreed upon close of escrow date, they can send a demand to close escrow to the buyer, or vice versa if the seller says, I need more time and the buyer can't wait. So make sure that when you are doing the steps, because demand to close escrow, you'll see the form, then they can cancel after the time allotted. But we need to do everything right, okay? So effective cancellation on deposits. So if a buyer or a seller gives a written notice of cancellation pursuant to the terms under this agreement, then they are also going to be releasing the buyer's deposit back to the buyer, less any fees. If there was any fees for escrow, like a cancellation fee or anything like that, they will be deducting that in escrow and then giving the remainder of the deposit back. So a release of these funds do require a mutually signed release instructions, which is a CAR form, and I'll show you. And we will be providing escrow a CAR form for cancellation and release of deposit. Escrow will then kick back an amendment, which all parties will need to sign, just so you know, okay? So a release of funds requires the mutual instructions signed by both parties. And, if somebody's just like, I'm not going to sign it because just don't want to, there may be, the party may be subject to a civil penalty of up to $1,000 for refusal to sign the cancellation if there's no good faith reason or dispute exists, okay? So there is something to try to move people along in the law on that, okay? So if you are in a situation where you're needing to deliver something like a cancellation of contract or a demand to close, Peter or I don't mind if you call us because I know it's not something in the course of everyday business that we're familiar with all the time. We're here to help you to get that delivered properly. We'll look at your contract with you, okay? So if you need to do one of those deliveries and you're not exactly sure, come to one of us. We're happy to help you on that. So repairs. Repairs need to be completed unless otherwise agreed prior to the final verification of condition of property. And the seller may perform some of the repairs, providing that the work complies with applicable laws, including permits if it's required on that type of work. And the repair shall be performed in a good, skillful manner with materials and quality and appearance comparable to the existing materials. And it says right here that the buyer's going to acknowledge that exact restoration or appearance of cosmetic repairs may not be an exact match or may not be possible. So the seller needs to obtain invoices and paid receipts for repairs that were performed by others. They need to prepare a written statement indicating the repairs performed by the seller and the date that the repairs were done, and provide copies of invoices and paid receipts and statements to the buyer prior to final verification. So I always tell you, when you're doing your VP, you make sure the refrigerator's still there, the repairs that you agreed upon, that you can see without climbing in an attic or a roof. But to really do your due diligence, make sure that you're obtaining receipts from the seller that that work was done if it was their responsibility. Okay. Final verification of condition, we call it the VP form. So this is not a contingency, but the buyer does have right to make a final verification of the property condition. So what they're looking for is that the property was maintained pursuant to this contract, and it is in the same condition that as when they wrote the offer, okay? So, and that repairs have been completed as agreed. So final verification, that VP form, very important. Make sure that you are out doing that and having your client sign it. Prorations of property taxes and other items. So the escrow officer will be prorating taxes between the buyer and seller as of close of escrow on items such as real property taxes, assessments, things of that nature. Now, if a utility bill comes in after the close of escrow, which does happen, make sure that if you get it as an agent, forward it to the other agent, but you see that it is anything that comes in after the close of escrow is handled directly between the buyer and seller. And remember that all prorations are based on a 30-day month. Even if you're in a 31-day month, all prorations are based on 30 days, okay, for any proration. And that is the figure that escrow will also use, okay? So this we normally don't have to worry too much about because the escrow officer is pretty much on top of all of the prorations. But I do recommend that when you're getting closer to closing, you get an estimated buyer's closing statement. If you represent the buyer or if you represent the seller, get that. Be sending that over to them a little in advance so that they can review all of these prorations, so that if there's any questions, it's not at the last minute. That can be handled with escrow and yourself and the client, okay? Broker and agents, the compensation, the seller or buyer or both agree to pay compensation to the broker as specified in a separate written agreement. That is your BRBC in the car case. So make sure that you have your BRBC filled out, signed no later than the date of your offer, but as soon as practical. Maybe you're out running to open houses with the buyer. Make sure you're protecting yourself with an exclusive BRBC. And right here it says buyer is advised that buyer's broker shall not receive compensation from any other source in excess in the amount provided in the buyer representation agreement. So you can't up your commission on an offer because the agent told you that they would pay more. You must not exceed your buyer broker representation agreement percentage, okay? And third-party beneficiary, the buyer's broker is a third-party beneficiary of this agreement and may pursue seller for failure to pay amount specified in this agreement. I haven't seen this used too much. I don't know if Peter has, but escrow does handle the commissions. As long as you have, your buyer broker agreement, you do not have to send that with your offer, but you may send it to escrow to make sure that they have the appropriate commission amount. And they will look at first the offer. Some escrow officers will ask for the buyer broker or maybe the listing agent. It's okay to send it, but you don't have to send it with the offer. What they're doing is making sure that you had it, that you're not asking for more than was in that agreement, okay? Scope of duty. The buyer and seller acknowledge that the agents are not deciding the price on what people should pay. They're not guaranteeing the condition of the property. They do not guarantee the performance of inspectors or services or the completedness of that. They do not have an obligation. Agents do not have an obligation to conduct inspections on common areas. They're not responsible for identifying defects in the property. That's very important. You know, we do an AVID, and we're having a great training by Robert Brand. We'll be going over how to document items on your AVID. If you see something, you need to document it. That would be on your AVID, okay? So, and we're not responsible as agents for identifying the location of boundary lines, square footages, things of that nature. So make sure that you stay in your lane as an agent. We're not, you know, the city, we're not going to be saying, I think the property line's here. You don't want to do that. Let them get inspectors, the appropriate inspectors, if they need any property lines, anything like that, they can have a surveyor come out. Square footages, we use the assessor's data generally, unless it's new construction. Sometimes you'll see it under an estimated square footage. And remember, as a buyer's agent, the appraiser will also be measuring that property, okay?
You know what, before you go any further, Michelle, what about easements?
Easements, okay, so easement, you want to get, this is why it's really important, you want to review that preliminary title report. And as I said, I don't remember when I said, it's been recent, call title and get a plotted easement report for free.
Okay.
So you can see where the easements are. You should be able to see easements on the prelim, get the plotted easement report. You can even tell the listing agent, hey, I see these easements on the property. Is there anything else that you know about? You know, maybe they've granted access to a neighbor. You can ask that after you've reviewed the report with the title officer and obtained your plotted easement report for free, okay, to give to the buyer. Joint escrow instructions, the following paragraphs or portions thereof are incorporated into those joint escrow, and you'll see multiple numbers here. You always want to review your escrow instructions before sending them, you know, to your buyer or seller. Sometimes escrow will send them direct, and if they do that, they're going to copy you, but you make sure that you're reviewing it too, okay? Don't just, you know, blindly send escrow instructions. Do your duty and your due diligence for your client and review them in case there's any questions, okay? So a copy of the agreement, this agreement, your RPA, will be sent over to the escrow holder within 3 days after acceptance. I recommend doing it ASAP. And I recommend that you get your fully executed agreement and all addendums and counters over to your lender ASAP, so you're not burning any of those days, those contingency days, because they need that to get started. So we do have up to 3 days, but I would go ahead and send it right away so you can open escrow right away and get it over to the lender so that they can begin working on it. And this paragraph authorizes the escrow holder to accept and rely on the copies and signatures that are in the agreement that you email to them, okay? And the escrow holder will provide a qualified substitute statement to us usually at the close of escrow, but make sure that you ask ahead of the close, because there's nothing worse than, you know, trying to get everything in that we need and not having something. So make sure that, I would say, you know, set a week ahead of time, relook at sky slope, make sure you have everything required. If not, start emailing escrow, hey, I'm trying to wrap everything up. Can you send me this? Even if they say it'd be in the closing package, I prefer to see it because I know they have it. So make sure that you're asking for those things so there's no stress at the end of getting documents that you need, okay? So brokers were, agents are not party to the escrow. The brokers are only a party for the sole purpose of compensation, okay, for commission. So we're not party to the escrow. So compensation disclosure, the escrow holder will provide the buyer a closing statement or other written documentation, and it will disclose the amount of compensation paid to the buyer's broker. So that will be disclosed to the buyer, and the seller will also receive a closing statement showing the commissions paid as well, or the compensation. Invoices, if you have, let's see, why would you need that? So sometimes there wasn't smoke detectors, and maybe you got the seller's permission to go out and purchase these smoke detectors and have them installed prior to the appraisal. So you have a bill and they say, just put it through escrow. So provide that invoice to escrow in ample time so that, for closing, because they're going to have the seller sign it and agree to it. So make sure if you're doing things like that, that you keep your receipts, you provide it to escrow in invoice format, and they will provide it to the seller to sign and approve for payment. So do keep your receipts if you're doing things like purchasing carbon monoxide, smokes, or anything that you've needed to pay for, okay? Usually we don't like to do that, but sometimes it's an emergency. You got to run out and do those things, okay? So verification of the initial deposit, the escrow holder will provide updates to the buyer and seller. They will let the buyer or seller know if the deposit didn't come in or the deposit funds were not good. So it is up to the escrow officer to notify you. However, being the diligent agents that we are, make sure that you keep on top of this yourself and that you're watching the days when the deposit should be in, and that you are verifying with escrow that they have it. If they do, ask them for the receipt right away and upload it into SkySlope and put a copy into your file, okay? So if you have amendments, you need an amendment that would affect any paragraph of this agreement. You need to deliver it to the escrow holder within 3 days after mutual execution of the amendment. So if you have an amendment signed, don't forget that affects the contract, any paragraph, give it over to escrow. They may need to write their own amendment to have it signed by all parties, okay? Selection of service providers. We do not guarantee the performance of any vendors, even if we recommend them. The buyer and seller can select any providers of their own choosing. So they can do the selection. If you want to direct them and give them some information on vendors that we know and have worked with, a list, you're welcome to do that. Ultimately, they can select who they wish, okay? This is a good paragraph, number 21, because sometimes we get calls after closings. So the MLS, the agents are authorized to report the MLS that the offer has been accepted. And upon close, the sales price and other terms will be posted in the MLS. Any pictures, videos, or floor plans or other information about the property that has been input into the MLS or, will feed to other portholes on the internet. We all know that. Those are going to stay. We cannot be removing them after close of escrow. So the California Civil Code requires MLS to maintain the images and information for 3 years on the MLS. As a result, they may be displayed or circulated on the internet, which is not, we can't control that. Seller or the agents can't control that. So it's stating here that the seller's agent, buyer's agent, and MLS have no obligation or ability to remove the images or information from the MLS. I get calls on this probably every few months where they're demanding the pictures down. We can't do that. So I'm just letting you know that if you need to point this out to another agent that is asking you to do this, it's right in the paragraph 21. Okay?
I mean, the only thing you can do is just go to the MLS and just say this has already been closed and all that, and then.
Right, but
Yeah.
the
They still.
population, those folders are still out there because they were uploaded on the MLS. And then sometimes people think we can control that later, but we can't. And paragraph 21 outlines it. So in case you get calls on that, attorney fees and costs, any legal action between the parties, buyer and seller arising out of this agreement, The prevailing party is entitled to reasonable attorney fees and costs from the non-prevailing party, except for as provided in paragraph 30A, which is mediation, and we'll get down to that, okay? So assignment or nomination. If the buyer is assigning this contract and escrow to their own trust, that's fine. They don't have to re-sign everything, right? But if it's another entity that is not wholly owned by them, then the other entity is going to need to go through all of the steps, CAR Form AOAA, and they're going to need to sign the contract. They're going to need to sign all the disclosures. Sometimes people do a one sheet saying they accept it all. I don't like it. I like initials on everything because I think sometimes, you know, they'll say, oh, I didn't see that. I would rather just have an initial. Just do the initials, you know, so that there's no question that they had a chance to review the contract, review the disclosures, and you have it initialed by them should an assignment occur. Okay? So a legally authorized signer. So the legally authorized signer, this is in pertaining to a entity, represents that the entity, they have to send, gosh, I'm stumbling. They need to send evidence that they are the authorized signer for that entity. This is very easy. They can go to the California Secretary of State. You can print off the statement of information and have that on your file so that you know you're dealing with the appropriate signer on the agreement. But at any rate, escrow will collect evidence that they are the authorized signer. They will direct you and that entity what type of documentation that they will need, okay? Definitions and instructions, I'm only going to go over a couple. You can read those on your own, as is a condition. The seller will still need to disclose any known material, facts, and defects as specified in this agreement, and the buyer has a right to inspect the property within the time specified, request the seller make repairs or take other corrective action. So as is, when we write as is in a counter, what does as is mean? How do they know? They don't until they go out and inspect, okay? So this is an as is contract, but they, you know, you still have to disclose material defects and those type of things that you are aware of, that the seller is aware of, okay? Now, if you, the agent, are aware of something, you can document things on your AVID, and we're having a very good training on that. I think it's next week. Counting days, make sure when you're delivering notices that you are counting your days appropriately. For a notice to perform, you can't deliver it more than 2 days prior to this, you know, the performance date. So you can deliver it prior to the date that they needed to perform, but only a couple of days ahead of time, okay? So if a scheduled performance day falls on a weekend or a legal holiday, then it moves to the next allowable performance day. So you can't make that performance day Saturday, Sunday, or a legal holiday. It will automatically move to the next day, okay? So I've underlined some stuff here. Go ahead and take your time and read the counting days paragraph. There's a lot of good information in there. Days means calendar days. The only thing in this contract that is business days is the initial funds. That's it. The rest all are calendar days, okay? Are counted by calendar days. So this is equal housing opportunity. The property is sold in compliance with federal, state, and local and anti-discrimination laws. The terms and conditions of this offer, everything is contained in this offer, and counter offers, there's no verbal, there's no anything like that, no old emails, no old agreements. It's whatever is contained in this contract. And time is of the essence. All understandings between the party are incorporated into this agreement. So this agreement can, or any provision of it cannot be extended, amended, modified, or altered or changed, except in writing, which will be signed by the buyer and seller, okay? So liquidated damages, these are only applicable if all parties sign. So let's say you submit an offer, buyer's agent, and the buyer has signed liquidated damage and arbitration of disputes, and you only get a counter offer back, right? And there's no full, your offer is not attached. Make sure if that's something that the buyer wanted, that you ask the listing agent, can you just at least send me the copy of the initialed liquidated damages and arbitration? And the reason why is because if it's not initialed and you expected it to be, you can't see that just with one single counter offer. So make sure that you get that back. For agents, I like sending everything back subject to the counter offer because then everybody has a complete set. So, but sometimes, you know, maybe they're in a huge multiple offer situation. So they're not going to send everything back, right? So, but make sure that if liquidated damage and arbitration of disputes was something your buyer initialed and they want, that you have evidence that the seller has also initialed it, okay? So mediation. So this is embedded into the contract. The parties agree to mediate any dispute or claim arising between them out of this agreement or any resulting transaction before reporting to arbitration or court action. So the mediation is conducted through CAR Dispute Resolution Center for Real Estate or through any other mediation provider that's mutually agreed to by the parties. So I just wanted to point this out. This is a lot of legal stuff. If Peter wants to jump in on it, mediation is built into the contract. Arbitration of disputes and liquidated damage are built.
Yeah, the mediation is built in the contract, but mediation is not legally binding. In other words, even if you agree to the mediation, it doesn't mean that you have to get any result from the mediation. The mediation, you can go through it, but if it's not successful, then then you can have other legal remedy, such as arbitration or legal lawsuits. So mediation is fine. That's the first attempt. It's kind of a amicable resolution of the dispute. But when you sign the arbitration, that means that you are willing to go into the arbitration and will be binding by the arbitration. So the arbitration will be final if you go through the arbitration. You cannot appeal. You cannot go through another lawsuit. Okay, so remember that. So, if you really don't want an arbitration, don't sign the arbitration paragraph. But the mediation is okay because mediation is not legally binding. In other words, even if you go through the mediation, you don't have to have a definitive result. Okay?
Okay, thank you. You have a question?
Okay, mediation and arbitration, you have to pay, right?
Yeah.
I cannot hear you.
She said on mediation, you have to pay. It does say that they're divided equally among the party.
That's correct. That's
Yeah.
correct. Arbitration, you have to do it. You have to pay too. Yeah, I know about. And arbitration is not cheap. Very expensive because you have to pay the retired judge. And the retired judge charge about $800 to $1,000 per hour. Okay, so sometimes the arbitration is even more expensive than regular lawsuit because the regular lawsuit you don't have to pay for the judge, you just have to pay for the court expenses.
Any other questions before we move off of this very important section? Okay. Okay, so if we have an entity buyer, you need to check this box. This will mean that you don't have to fill out the RCSD. So if you check the box, you need to put in the full name of the entity here and who's the authorized legal signer here for the buyer. So if it's an individual, no need to check that box, only if it's an LLC or some type of entity, even a trust. Who's the trustee? You're going to put it here. Okay.
So 2 is who's gonna be the actual signer, right?
Yeah, who you have to fill in who it is, who the legally authorized signer is, because sometimes somebody will check this and they don't fill in any of this information. We need to have what is the name of that entity or trust and who is the legally authorized signer or signers. Okay. And then if that's the case, you're going to check here. If it happens to be an entity and not an individual, as Sam Smith is, you check here, put the legally authorized signer's name. If there's a title, fine, you can put it in. If not, you don't have to. It may be a trustee. It may be a managing member of an LLC. But at any rate, if you check the box, then you avoid having to do the RCSD later, okay? And the same goes on the seller side. They can also check the box and sign it as an entity. Now, acceptance of offer. So the seller has a choice. They can just accept the offer, or they can check the box that they are going to be issuing a counter offer, or that they're offering a backup offer. So they can check either one of these boxes. Here's the entity box if the seller happens to be an entity. So make sure if you're countering that you do check the counter box here. Okay, sometimes the check is small, so for the other agent, you may want to highlight it with a yellow highlighter and then email it over so they see the check, okay? And they'll see the counter at any rate, but you want to make sure that you check that off. So I want to come over here. This is really important. So when you are filling this out, I'm at the final page 17. Okay. So this is an important component, this email address here. So I'm the buyer's agent. I've got my email. I would have put a phone number. This is, I'll put my phone number too. But this is my designated electronic delivery address is the email above, or if I modified it here. This is really important because once you hit send on a document to that email, you've delivered it, okay? So make sure that there's email addresses here. So the seller's brokerage, here, you're probably not going to fill out their designated to be filled out by the seller's agent. So make sure that when you're getting this back, and if there's not an email there, just mention to them, hey, could you add your email and send it back to me so that you have that designated email address, because it's so simple. Once you hit send, it's deemed delivered. You just keep record of your email, okay? Notice of buyer to perform. I'm going to quickly go through a few forms. So here's the notice. You can notice them to perform number 1, I would call it. And you're going to ask them to either remove all contingencies, but maybe they've removed some contingencies and they're almost at the end. Hey, can you now remove your appraisal contingency? Whatever you're asking them to remove, check it. There's contractual actions here or contingencies here. So make sure that you're using this. You can use it in steps. That's why it's number 1, number 2, or ABC, however you want to number them. It can be done in steps. But generally, when you get to the notice to perform, buyer to perform, they're checking for all contingencies to get removed. And if you think, oh, I don't remember if they removed that, it doesn't hurt to just check all contingencies, okay? Then the seller will sign and date it. The buyer has 2 days to correct, or you can amend it here. And you cannot give them less than 2 days to make any corrections, okay? Or removal of contingency, I should say. So I just wanted you to be familiar with that page. So notice to buyer to perform. You're going to number it. Buyer contingency removal. This is what it looks like in case you guys need a refresher. Here's down here on 3, all buyer contingencies are removed. This one can be numbered too, and you can do it in steps. As you can remove them, it's good to show good faith to the other agent and begin removing those contingencies that you can. Maybe you can't remove them all, but you can remove some, okay? When you answer, and I didn't pull up a request for repair, as a listing agent, if you agree to items on a request for repair, you always make it subject to your attached buyer contingency removal. You will attach that to the request for repair, making it subject to them signing that. You give something, you need to get back what you need, those contingencies removed, okay? So always remember that, and you give something, you need to get that back, okay? So make that a part of your request for repair always if you're a listing agent. Notice of seller to perform, again, there's numbering here, and these are the contractual actions that the buyer would be asking them to take. Delivery of car form solar, anything in here, fire, hardening, and defensible space advisory, things like that. So if the buyer needs to notice the seller, there is a notice to seller to perform. And again, they have 2 days to remedy that by performing, okay? That's why that email at the back of the contract is so important, because what you hit send to the other agent, it's delivered, okay? You just keep your email as evidence. And here's the seller contingency removal if any of these apply. Closing on replacement property, substitution of eligibility for VA loan, things of that nature. So you see the seller contingencies are very little, okay? Demand to close escrow. So if you're in a situation where the seller says, you know, I know they've asked for another whatever, I don't want to grant that. So you need to send a demand to close escrow, that you put the agreed upon close date, which was here, or you check A, you have to put that there. You check either A or B, check A within 3 or whatever, if you give them 5 days, but no less than 3 days of delivery of this demand to close, but no earlier than the agreed upon close date. So, or you can just do it by date. Seller hereby demands the buyer close escrow on the property by, what's the date? Or by within how many days? 3 days, or are you going to amend it to 5 or something? Okay, so the seller would sign in date, that would be delivered. Or there is a section here where the buyer can demand the seller to close. So it goes either way, right? Maybe the seller can't get out or something, but the buyer needs to get in. So it goes both ways. So very important document up next. I just want to briefly go over the cancellation of contract, disposition of deposit, and cancellation of escrow. If you are in this situation where you need to prepare this document, we are here to help you. So we want to help you with it if you need it, okay? So this is a very important document. Even if you have zero money, $50 in escrow, whatever, you need to cancel the contract. There is no, oh, there's no money in escrow, so I don't need to cancel anything. You do. You have an open escrow. You have a signed contract. You still need to cancel. So cancellation of contracts, there's 2 parts to this form. So who's asking, the buyer or the seller? So in this case, I've given you example. I'm going to say, hey, the buyer's requesting. And then I'm going to check down here. This is normally what it's going to be. I'm going to check as permitted by good faith exercise of paragraphs 12 and 8C. I do have those queued up in here. I'm going to show you that. So you can use those as your good faith. So here, please don't write that the buyer lost their job, the dog ate their homework. You know, don't do stuff like that. Because it has to be canceled. Good faith was something pertaining to the contract, not that they lost their job or something. Okay, so just put it in, and I'll show you what 12 and 8C mean. So, and there's other boxes you could check here, read through them, and check the appropriate one, or you could check proposed mutual cancellation if that happens to be the case. But you can do a single party delivery of this. So the buyer or seller, the party canceling the contract would sign and date it. But we have one more page. What about the disposition of the deposit and cancellation of escrow? That's what page 2 does. So you're going to fill in the escrow number. The escrow company goes here, and you're going to read these boxes, which one is going to pertain. Normally what I see is they're going to check C1, that the seller is authorizing the release of the buyer's deposit, less any fees and costs that the buyer has already incurred. So that might be a cancellation from escrow. That would be their cost. Or if checked, the seller agrees to pay for the buyer's out-of-pocket expenses for inspection reports, appraisal fees, as specified in the agreement. So, or that could be checked along with this one, okay? So just read these and check the appropriate box. Again, we are here to help you with this, so don't feel nervous if you've never done one and you need to. Just come over and ask. We're here to help you. So then the buyer would sign and date it, and then on this one, we do need the seller to sign and date it. Once you have this one fully executed and the front page signed by whoever requested the cancellation, send it over to escrow. They're going to prepare their documents to cancel. Okay?
Okay, now just remember that the cancellation of escrow needs two parties, mutual agreement, okay? So even though the cancellation of contract can be unilateral, that means it can be either by the buyer or the seller, but the cancellation of escrow, you have to have mutual agreement between the seller and buyer. Even though you have successfully canceled the contract, it doesn't mean that the escrow is canceled. If you cannot get the mutual agreement for both the buyer and seller. So this is very, very important, okay? Because you think that right, there's no more contract, so there's no more escrow, and so I can sell it to the other buyer. No, then you make a big mistake, because the first buyer can come back and sue everybody, and that's what we had a lawsuit like that, and we had they settled the lawsuit for over the $100,000. So be very, very careful, okay?
Yeah, and if you always use the CAR forms, because they've lined all this out, the CAR attorneys, and always, if you're trying to do something, find the CAR form. If you can't find it, ask one of us, we'll help you. That you always have access to the CAR legal hotline if you're a CAR member. So use the CAR hotline, or us will help you. But do use the forms. It's going to protect you a lot. So I wanted to show you on this one. So paragraph 12, remember, I canceled it in good faith due to paragraph 12, which was my buyer's investigation of property and matters affecting the property. And then I also said, and 8C. So investigation of the property, the agreement as specified is contingent upon the buyer's acceptance of the condition of and any other matters affecting the property. So I'm doing a good faith cancellation in this example due to investigations and my non-acceptance of something that I found out, okay? So 12 and then paragraph 8C, and it has to be, you can cancel for other reasons, but it has to tie to the contract. It can't be due to a contingency that you've already removed. You can't go back and use that, okay? Good faith on a contingency that's open and it's not canceled, that's not already removed, okay? So we can help you with this. If you explain the situation, I'm sure Peter or I will be able to help you, okay? There is a form, I'm just bringing it to your attention, a non-contingent offer advisory. If somebody's trying to, make a non-contingent offer, do have your buyer sign this form, because they are going against the advice of the broker/agents, okay? Verification of property condition. I wanted to bring this in because if you have a buyer that says, I'm not going to do that. I'm not going to go verify it. I'm not in the state. I'm not around. I don't want to. Please waive it then. We need a waiver and we will require it. You check number 3, that the buyer waives the right to conduct their final verification of property condition. And if they do not verify the property's condition, then the buyer is acting against the advice of the broker. We always advise them to go do their final walkthrough. But if they can't or they won't, then you need to check this box, ask them to sign, and have the seller sign as well so they're aware. This just populates the federal reporting requirement purchase addendum. These are auto-populates with your RPA. So I just left it there. The buyer signs, the seller signs, this auto-populates. We all know that the buyer's investigation advisory populates with the RPA. So go ahead and have that signed by the buyer. Possible representation of more than one buyer or seller will always populate with the RPA. So go ahead and give that to them and have them sign it. And you will also be signing as the agent here, the buyer's agent in this sample, okay? Fair housing and discrimination advisory always populates with the agreement. So have them sign that. And, I really recommend that we as agents read these forms ourselves. It's good to just read them and be familiar with what they're telling you. Buyer homeowners insurance advisory always populates with the RPA. Have them sign and date it, and it's a good time when they're signing this to remind them that once they're accepted, to be talking to their insurance agent that very same day for insurance on that property, since we know the costs are high and it's taking longer. Wire fraud and electronic funds transfer advisory will always populate. Have them, the buyer sign and date it, the seller will sign it. And finally, the last is the CCPA will always populate, have them sign and date it. These will all be required on the SkySlope platform, so make sure that you're just following along with the offer and having them signed. And if you have any questions, please let us know. Peter is here to answer anything if anybody on Zoom or in the room has questions for him.
Yeah, anything, any questions?
Anything you guys need to
I
know?
had a situation a long time ago where the buyer, Peter,
Yeah,
his time, he didn't qualify for the loan. I was a listing agent. And he didn't qualify and I wanted to cancel the contract.
okay, do you have the loan contingency in place?
Yes, everything.
Well,
Yes.
then, that's fine, then you
Yep.
just
No,
say
no,
that it's
my
loan.
question is, we could unilaterally cancel the contract. How long does escrow, or what does escrow do so I can accept another buyer?
Oh, then you have to cancel the escrow too.
How
If
do
you
you-
want
how
to
long
have
do you wait?
the
How do you
first
cancel
money
that?
deposit
If
back.
the guy wanted to take legal action.
You have to have subject to cancellation of previous escrow noted on the MLS
Yes,
if you
yes.
don't have evidence cancellation.
Yes,
But
because if you
couldn't-
don't have if you still have escrow active, the buyer can always come back and sue everybody, you
Yeah,
know?
he says, I need more time. I said, well, I got like 3 other buyers waiting. Do I have to give him more time?
Okay, you
He was
can
threatening to sue us.
you can make a contract with the second buyer, but you have to specify that it's contingent upon the successful cancellation of escrow for the previous buyer.
It could be forever lawsuit.
Forever,
No,
then
I'm not. gonna-
then the seller can always go to court and resolve that.
Right.
Yeah.
Okay, thank you.
Sure, you're welcome.
We're stuck.
Any other questions? Okay, if there's no other questions, that concludes today's training. Thank you for
Michelle.
sticking
All right,
around for
thank
the
you.
session 3. Appreciate your time and
See
have
you
a
later.
beautiful weekend. Goodbye, everybody. Thank you
Thank
so
you,
much.
Michelle.
Bye-bye.
Lunchtime.